All right, continuing chapter 8, 8.7. Enforcement discretion. Reasonable minds can differ whether the enforcement action is necessary to given the situation, and so which action is preferable. What important is every inspector, specialist, chief inspector, regional manager be familiar with it and apply these criteria. Do so with the help of the effectiveness, fairness, and acceptable level of consistency. Exercising discretion, consistent application of the criteria will also be in accordance with the FRA policy of the focused and enforced, i.e., used with the limited resources to attack the most serious and persistent compliance problems. It is important to note that the enforcement discretion being applied is that of the agent, while the inspector makes the initial determination need for the enforcement agent action regional personnel within play inactive is an important role of reviewing those determinations with the goal in ensuring the effectiveness, responsibility, consistency. Supervisor, road safety specialists play a primary role in ensuring the field inspectors that have data necessary to make informed enforcement decisions. Toward the end of the headquarters, the field personnel analyze the data using the dashboard analysis system on a rotating weekly basis. Additionally, supervisor, railroad safety specialists, and the regional administrator, deputy regional administrators analyze the data in the incident inspections data program in the areas the regional railroad shipper level. The information should be used in deciding whether to inspect, but also in making enforcement decisions. Office of Railroad Safety and Headquarters, the personnel will input their region reasonable for spotting the national trends, but requiring the enforcement action for providing guidance for the regional field and safety difficulty enforcement policy issues. Even when the law does not require the FRA should the offender minimally state a culpability as a factor should be considered for deciding whether to take enforcement action. For example, the violation had been made, but the result of the good faith misunderstanding of the relevant law, which often happens with the regulation for brand new, inherently ambiguous unless the violation varies seriously. Enforcement action was orderly, not appropriate whether there is a solid evidence that such a good faith mistake was fact and cause. Such good faith mistakes, which imply with the honesty attempt to know and obey the law, should not be confused with simply ignorance of the law resulting from the failure to know it. Culpability is also very low with the violation discovered the property of one company that had not a reasonable opportunity to correct if the violation was clearly more attributed to another company. For example, there is more true with regard to the equipment defect of the receiving the railroad was hauled the car with only a short distance for the interchange of the major repair point. With the FRA is confident. The FRA is confident based on the experience that the location that the violation would have been caught but corrected by the receiving railroad, even the FRA had not been present. The better candidate for the enforcement action would be delivering the railroad if the evidence indicated the defect was present when the railroad delivered the card. Likewise, the pre-carded tank car is found with the railroad property with loose fittings that could not be observed with the ground or no evidence is leak. A culpable party is not nearly always the car's offerer. The offerer is primarily responsible to ensure all the closure on all the cars secured with such manner to remain secure under the conditions normally intended by the transportation. To get a root cause of the problem, violation should be taken against the offerer unless the same evidence of vandalism, extreme rough handling, and sense of the car left the author. While very low culpability might tip the inspector's discretion toward not taking an enforcement action, a very high culpability may have the opposite effect. For example, the clearly egregious violation may be warrant enforcement action, even if so isolated, not especially serious. Blatantly disregard of the law, even though on relevant lesser matters, may indicate an overall poor attitude toward compliance that could carry over the very serious matters. Inspector regional personnel are not expected to spend hours deliberating about every possible enforcement action. Instead, these guidelines intended to provide with the framework that enforcement personnel will incorporate their entire enforcement approach so that the focus weight quickly and effortlessly in most situations. Of course, sometimes the time spent with the factors should correspond with the serious situation. 8. Enforcement tools. The inspector, with the guidance of the difficult cases of the regional headquarters staff, needs to weigh all the factors determining the appropriate course of the action and deciding whether the more severe action with the implicit warrant conveyed with the inspection report is necessary. One consideration is choosing the recommended formal enforcement action entails with a considerable investment time to prepare the violation reports, obtaining the necessary supporting documentation, time preparing the violation reports, and time not spent inspecting, but so it may sense in terms of time allocation for the inspector to choose the carefully and enforcement action of those violations that due to seriousness and frequency and other reasons are most is needed being deterred. When a hazardous material inspector has decided the enforcement action is necessary, a variety of tools are available below, or a brief discussion of each of the available tools. 881. Defective notice and spoken warning. Even an inspector has decided no enforcemental action will be taken with identified with the defective condition. See verbal interventions, Chapter 3, General Manual. The inspector must complete with the defective notice of the inspector, and this necessary adequately collecting all information needed to make the fitness determination of carriers, shippers applying the special permits and approval. 882. Warning to an individual. Warning to an individual discovered to have violated the regulation of the laws may be issued with a verbal warning documented on the inspection report by the regional staff director or the office of the chief of the council. Warnings are intended to put the individual involved with notice and he or she violated with the law regulation. Inspectors should follow the procedures outlined in Chapter 3 of the General Manual. 883. Civil penalty against the railroad or offerer. All enforcement tools available to the inspector use the civil penalties against the railroads must frequently than others. To assess the civil penalty against the railroad or shipper, the FRA must prove the knowingly violation of the hazardous material regulation. Unless it determines that the most severe penalty is needed, but the FRA usually follows the penalty schedule for the relevant section of the Code Federal Regulation. Penalty guidelines are published in Title 49 CFR Part 209 Appendix B. In the event that the inspector recommends the assessment of the civil penalty for the multiple days for the aggravated penalty amount for the procedure outlined in June 18, 2009 joint RCC and RS memo must be filed. The memo is included in a manual in this manual Appendix C. All right, 884, extraordinary civil penalty. The FRA may assess civil penalties up to $100,000 per day for the violation of the hazardous material regulation resulting in death and serious illness, serious injury to any person, substantial destruction of property. Title 49 U.S. Standard Code 5123, Title 28 U.S. Standard Code 2461, note. In the event of the inspector recommends the assessment of the extraordinary civil penalty, the amount proceeds outlined in June 18, 2009 joint RC-RS memo must be filed. See Appendix C. 885. Civil penalty against an individual. To assess civil penalties against an individual for violation of hazmat material regulation, the FRA must demonstrate that the individual both knowing and willfully violated the hazmat material regulation. Inspector and regional management most locally work closely with the office of chief of council to assess this type of penalty. 886. Compliance order. When the cooperative approach has been not worked, if the civil penalties are either inappropriate or have been proper and effective with the particular circumstances of the violation, do not create an emergency. The FRA issues the compliance order directing the party to comply with the regulations issued under either the Federal Railroad Safety Laws, Hazardous Material Transportation Laws, see Title 49 U.S. Standard Code 5121A 2011B. Inspectors of the regional management must work closely with the Office of Chief Counsel to pursue these type of the remedy. All right, 887, disqualification of safety-sensitive service. When a railroad employee is found to have committed a series of safety violations or a particular series of violations such as individual fitness to perform safety-sensitive services, includes service subject to the Federal Hazardous Material Transportation Law or hazardous material regulations. FRA must disqualify the individual from performing safety-sensitive service. As finding willfulness is not prerequisite, but is demonstrated that the individual is unfit for the safety-sensitive service. See Title 49 CFR Part 209 Subpart D. Disqualification achieved through a notice of proposed disqualification issued through an office of the chief of the council. An inspector who suspects a disqualification action must be justified should be in his or her regional specialist as soon as possible. The regional specialist should consult regional management. If the management occurred, the region should contact the Hazmat Material Safety Director and the RCC individual liability expert for guidance. All right, 888, injunction. Injunction is a court order from the U.S. District Court judge requiring a party to comply with the law immediately. The FRA uses the tool to stop the pattern of the violation that do not present emergencies by which the railroad or shipper has not acted upon to prevent, despite civil penalties or other warnings from the FRA. Inspector of the regional management must work closely with the Office of Chief Counsel to pursue the type of the remedy. 889, railworthiness directives. The FRA determines based on the existence of the problem caused of the tanker car or class or design of the tanker cars may be unsafe for the operating condition. The FRA may require that the cars be inspected without regard to any other periodic inspection requirements. These agencies issue a railworthiness directive that describes the condition or defect, orders the testing inspection of the tanker car. Additionally, the directive requires correction of all defects, unsafe conditions, whether determining federal standards under the Association of American Railroads Tanker Car Manual. See Title 49 CFR 18509. 8810 one-time movement approvals. The FRA may issue approval to move bulk packaging do not conform with the hazmat material regulation on a case-by-case basis. Generally, these movements approvals are issued by the headquarters of the hazmat material safety staff and are consultation with the interested regions. However, as stated with the approval documented, the approval does not preclude enforcement action for the transportation of non-conforming packages prior to the issuance of approval. See Title 49 CFR 17450, Chapter 9 of this and Chapter 9 of this manual. 8811 emergency order. If the FRA determines based on the testing, inspection, investigation, research of the unsafe condition, practice, combination creates an imminent hazard of death or serious injury, the FRA may issue an emergency order to impose restrictions, prohibitions necessary to abate the emergency situation. A hazard is imminent if the reasonable likelihood to result in death or serious injury to the public or railroad employees before civil penalty or action or compliance or order proceeding could be expected to produce a remedial action. Inspectors and regional management must work closely with the Office of Chief of the Council to pursue the type of the remedy and see Title 49 CFR U.S. Standard Code 20104 and see Title 49 CFR Part 209 Appendix A Extraordinary Remedies. And 8812 criminal penalty. The federal hazardous material law provides the criminal penalties a monetary fine and or imprisonment for any person who willfully, recklessly violates the hazardous material laws of the hazardous material regulations. See Title 49 U.S. Standard Code 5124 for because the FRA has to work with the U.S. Department of Justice to pursue criminal penalties. Inspector of regional management must be worked closely with the Office of the Chief of the Council to pursue the type of the remedy. Accordingly, if the inspector believes the criminal violation exists, and the regional specialist, the regional administrative office, the Chief of the Council should be notified as early as possible in the investigation. All right, 8-9, deciding which enforcement option is appropriate. When the inspector has decided with merely reporting his or her findings of the company's individual discussing the need for the improvement in compliance, but is unlikely to have sufficient deterrent effect, and under the circumstances, the inspector will decide which the enforcement tool is most appropriate. The violation creates an imminent hazard of death and serious injury, and the inspector is not confident or of immediate corrective action. The consideration should be given to an emergency order in the case of the situation that may require an emergency order. Immediate cancellation of the regional administrator is essential. Remember that the emergency orders can be used when the unsafe condition does not violate existing law of the FRA. It can make rational case of the conditions in practice create the hazard of death of injury. If the violation presents a very serious risk of death or injury, both the risk of the not so imminent, the warrant emergency actions, violation actually caused by significant harm, death, injury, and substantial hazardous material release, consideration should be given to the civil penalty case of the recommendation of aggravated penalties when submitted with the Office of the Chief of the Council. Such a report must include a cover the memorandum for the region explaining the basis for extraordinary penalties of the ordinary schedule amount of the multiple days, and such penalties recommended with the report indicated with the basis that the recommendation has a material area, a penalty up to $32,500 per day, a violation possible where the growth and negligent violation, pattern repeated violations have been created with an imminent hazard of death of injury to personnel have caused death or injury. Extraordinary penalties shall never be recommended without providing with the necessary support with the recommendation, because of this will only delay the transmittal of the penalty demanded latter. The situation is one that does not rise with the level of the emergency, but the sheer volume of the violation of the recurring nature suggests that the measure of the other than civil penalty might be necessary to obtain corrective action on a specific problem. Consideration shall be given the recommended with the compliance order or injunction. A compliance order entails the possibility of administrative hearings before the order when they've been issued, so that it is not a tool designed to extremely quicken action, but it would most likely be useful only on the most clear-cut, repetitious violation, whether the FRA has reasonable, well-defined remedial action from the offender and has been met with resistance in such situations. The compliance with the order of the proceeding may provide with the extra leverage the FRA needs, but not result with the cumbersome litigation because the facts are indisputable. Injunctions are court-ordered prohibition violations that are added to the weight of the court as the content of the powers of the further FRA compliance efforts. However, to obtain such an injunction, the FRA will first persuade the U.S. Department of Justice of the need for such extraordinary relief, and assuming the Department of Justice is willing to file suit, the FRA will then be able to persuade the court that it should issue an injunction. The tool is most likely to be used where civil penalties alone have been ineffective in lessening the frequency of a particular type of the violation. Violation is serious and the company's unusual obstinate and safe behavior. Individual liability, including warning letters, civil penalties, is a tool that should be considered within any of the situation when deterring a particular individual. Compliance is what is most needed. The tool is specifically useful where the violation arose with the individual's owner's choice, where this violation is more attributed to the corporate policy, the failure by the company to properly train and supervise the individual. The company is usually better target. Unless the policy failure can be traced directly to the specific individual, the inspector need not to be individual liability, corporate liability. In some situation, enforcement action against both will be warranted. Finally, under Title 49 U.S. Standard Code 124, a person willfully, recklessly violating the federal hazardous material transportation safety laws, regulation, and implementing it is liable criminal persecution. If the inspector believes that a criminal violation exists, the regional specialist, the regional administrator, the office of the chief of the council should be contacted as early with the investigator as possible. If the officer or the chief of the council, after the legal elevation of evidence concurs with the recommendation to pursue the criminal sanctions, chief counsel will refer to the Department of Transportation Officer Inspector General. As a matter of caution, evidence in the criminal cases may become tainted through improper handling by custodians. In addition, a criminal investigation involves the constitutional rights of the respondent and defendant. This means the early consultation of the office of chief of the council is necessary. It also means that the access fact of the case shall be limited to those that with needed to make the policy legal decision. A particular case becomes a matter of for criminal court success. The evidence will be severely restricted by the federal rules, and this task is easier if the facts have not been subjected to wide discussion. 8.10. Determining the existence of a violation. The hazardous material regulation requires certain elements of the being present for the violation to exist. A person subject to the regulation must submit an act, and in most cases offer acceptance of transportation of a shipment that does not comply with the regulation. The civil penalty to be assessed. The action must have been committed knowingly. The actual knowledge of the fact that was presumed knowledge of the fact that would have been obtained with the person exercised reasonable care under the circumstances. In order to determine what the reasonable person is, the test of the is functional. Anyone engaged in the activity covered by the hazardous material regulation is responsible for the proper accomplishment of the activity. In addition, with the regulation containing the trigger events, actions to be taken by the person after this person may be held responsible for the compliance and non-compliance with the regulations. 8.10.1. Person who offers who offeree or the offers. Generally, a person that must perform regulated with a hazmat function to be held liable for the violation. See the discussion of the FRA scope of the regulatory authority in Chapter 2 of this manual. Under traditional commercial law, the offer of transportation occurs with the billing and landing is prepared with the sign by the however the offer of the transportation may occur when the person takes the action indicated with the preparation of the car is complete. The car is ready to be picked up by the railroad. These actions, depending on the customary practices of that person, may include notifying the railroad that the car is ready to be picked up, transmitting the shipment papers to railroad electronically by placing them with the near of the car, placing the car on the ready track, the clear statement, and authorize our representative of the offer that the shipment is ready for transportation. Other indicators of the offer and completed with the preparation shipment presence and appropriate road residual placards, seals on closures, and all these elements to be needed to analyze, determine whether an offer has been made. For instance, violations in secure closures, which are found on loaded tanker cars after the manway cover over the lid, protective housing has been sealed, may be the violation under Title 49 CFR 173.24b and F, or 173.31d.1.4, which requires fittings to be properly conditioned for safety prior to shipping. The theory is that once seal is applied, the officer has no other further intention to recheck the car. However, we would also want to check whether the offerer had signed the shipping paper, notified that the railroad, etc., with the officer's specific intentions were with respect to that car. It was possible that despite the presence of the seals, the offer intended to recheck the shipment prior to the actual offer. The point to remember is, what do we not necessarily have to demonstrate the shipment left offers a property in order to show how that it was offered for the transportation in non-complying condition. By addressing the criteria discussed here, we may be allowed to show that for all the particular purposes the offer had effectively made it before the railroad actually hauled the shipment away. However, we do not want offers cited with the violation necessarily entail with the other in an offer situation in which the officer can demonstrate by reference to specific facts that it was offerer's intention to inspect, remedy for non-compliant conditions before the shipment left properly. Certain regulations may be violated before an offer is made after a receipt is completed with the shipment. The C discussion of the FRA scope of the regulatory authority in Chapter 2 manual. This situation proof in an offer that an offer is unnecessary. Instead of the inspector must demonstrate that when what regulated the hazardous material functions were performed in non-compliance with the hazardous material regulations were required to perform and were not. Inspectors will evaluate the situation in light of the specific wording of the relevant regulations during the load and unloading operation. Non-compliant activity itself usually triggers the violation. Examples are figured to place appropriate caution signs on the side of the track during unloading and improper loading, or specific materials. In some situations, violation may exist even before the hazardous material is actually tendered to the carrier for the transportation. When a pre-transportation function is performed in not compliance with the hazardous material regulations. All right, 8.10.2 originating carriers. The trigger for the railroad is the acceptance or transportation of shipment of the hazardous material. See Title 49 CFR 174.3. Under traditional commercial law, the acceptable occurrence with a bill landing is signed by the carrier. The acceptance of an originating carrier can also occur when the carrier is taken the physical possession of the car, and e.g. by the coupling of the car or moving it with the concept of agreement with the definition in service of the FRA's freight car safety standards. See Title 49 CFR 215.5E. It should be noted that the carrier may deem to have accepted the car and become liable under the hazardous material, even though no offer was made. For instance, the carrier must remove the car with the officer's facility, although the offer has not been taken and offered the car for the transportation. In the case, the carrier will be liable for defects, such as it has been accepted taking the car, while the acceptance is noted above the relating of the pre-transportation functions. The offer is not, and since it was never offered for the car, the presumer could argue that it could not complete preparing the transportation. Alright, 8.10.3 non-originating carriers. Non-originating carriers come under the regulations when they accept the car and interchange by placing it into service, usually by uncoupling it to, usually by coupling to it. Alternate methods of accepting may be created, but the agreement between the railroad must be examined on a case-to-case basis. The living carriers remain responsible, of course, for all violations occurring upon that point. Alright, 8.10.4 manufacturers. A manufactured packaging generally becomes the liability of compliance with the hazard material law regulations when it marks the container with the Department of Transport specification. 8.10.5 repair and recondition with the facility. A repair recondition facility becomes liability not compliant with the hazard material law regulations when it performs a repair or other function regulated with the hazard material regulation, subject to the hazard material regulation packaging standard of the repair. The activity does not comply with the hazard material regulation. Circumstances outside the scope of the example that are possible entities other than those listed by that may violate the hazard material regulations. Inspectors should seek guidance from the specialist on how to proceed with such circumstances. Alright, 8.11 interregional coordination. The need of the interregional coordination is more important than ever with consolidation of the railroad industry. Interregional coordination has been improved in the past few years, and we're strongly encouraged further coordination to avoid inconsistent enforcement activities. We need to ensure that the continue to assess whether a specific issue might extend beyond the specific regional boundary. Regional headquarters specialists, through the periodic conferences, emails, telephone contacts, need to play a key role to ensuring the system and the compliance problems are addressed and coordinated rather than piecemeal approach. Railroad system oversight managers should be involved with the discussion regarding major interregional enforcement issues, should be provided with information to specialists on system compliance problems, especially those on which the cooperative efforts are not achieving results. 8.12 enforcement actions against individuals. 8.12.1 principles. The federal hazmat and transportation law at Title 4 U.S. 49 U.S. Standard Code 5123 states that a person knowingly violates hazard material law regulation is liable to the U.S. government for a civil penalty. This is a standard very similar to the use conjunction with the individual liability case prosecuted under the state railroad safety laws. See Title 49 CFR Part 209 Appendix A, which provides that willful violation is one of the intentional violation or voluntary act committed either with knowledge of relevant laws and reckless regarding whether the act violated with the requirements of the law. A penalty of up to $100,000 per violation are available under hazard material law for individual violations. Consideration of totality of the circumstance. Inspectors will determine the totality of the facts, circumstances with their actual knowledge of the reckless disregard of the regulations is present. Clear-cut example: the willful violation occurred if the violation acts committed or by or either direction of the individual following the specific warning of the FRA inspector thereto. An individual that such an act would be a violation of federal law. However, there is not only the possible situation that establishes individual liability. Inspectors should thoroughly investigate to gather all relevant information for determining from the information as necessary standards may be proven. The FRA and inspector discretion. Individual liability is an important tool, should be used appropriately where it will and achieve the desired result. Overuse, the use in questionable weak cases will damage the FRA's credibility and effectiveness of an enforcement tool. The individual liability is a tool that should be considered with a situation where deterring a particular individual's noncompliance is what is must be needed. The tool is especially useful where the violation arose by the individual owns choice. The FRA has discretion to pursue the enforcement action against the railroad, the individual, or both. The decision should be dependent on the culpability of the respective parties. The inspector should not be afraid to use his or her discretion recommended individual liability when warranted, but the inspector should not threaten individuals with individual liability actions. Instead, an inspector should communicate to the individual that if the practice continues, the inspector might have to recommend to the supervisor that the individual liability be considered. Of course, at the same time, an inspector should be absolutely sure the violation would be probable or worthy cause for all the reasons. Earlier communication between the investigating inspector, and regional specialist on potential individual liability is critical. 18.8.12.2 level of individual liability to recommend. The decision to issue a regional warning letter. Usually a regional warning letter will be used the first time offense where there is doubt to be offended with the employee's knowledge of the law, where the offense is not highly serious or warning is deemed adequate to prevent reoccurrence. When an inspection is determined the individual should be issued with a regional warning letter for the violation, the inspector should orally advise the individual of these facts, including the fact that the inspector intended to recommend that a written warning notice be issued to the individual. This will ensure the individual immediately knows that he or she performed an unlawful act and should not do so again. The circumstances included in the time of the violation and the time the individual was so notified should be carefully noted by the inspector. As soon as practicable, the inspector should contact his or her regional specialist who will arrange the conference call with the regional administrator, regional staff member delegated by a director. The specialist is not available. If the specialist is not available, the inspector shall direct the contact to the regional administrator. Once it is decided that the facts support at least the issuance of a regional warning letter against the individual, the inspector will submit the completed FRA Form 6180. Regional administrator making sure to check the item for no to indicate that no formal enforcement action will be recommended. The regional administrator will then co-sign the form and mail the original first copy to the individual by registered mail. The regional administrator will insert the regional subsequent full calendar year report number in the space provided with the upright corner of the copies. Only will mail the appropriate copy to the office Associate Administrator for the Railroad Safety Chief of Safety Officer, and if the individual envelope with the S6 18080 marked on the outside of the employer copied to the individual employer and retain the appropriate copy to secure the regional file. Regional warning letters can be issued by the region with the RCC involvement or the Railroad Safety Chief staff must provide a copy of the letter of the FRA Form 618080 once issued. The headquarters warning, the letters and emails and information of the FRA attorney for the region in which the incident occurred and or subject matters of expertise notify the RCC attorney assigned to coordinate with the individual liability action. If subsequent determined that no violation occurred, but the inspector must contact the individual to discuss the circumstances that led to the verbal warning and explain why the warning was not valid. Alright, decision to recommend to the formal chief of the council warning letter or assignment of the civil penalty. When an inspector or regional administrator determines that the individual should be issued a warning letter from the office of the chief of the council to assess the penalty, the inspector should orally advise the individual of the circumstances surrounding the violation, including the fact that the inspector intends to recommend formal enforcement against the individual. This will ensure the individual immediately knows that he or she performed an unlawful act. The circumstances including the time of the violation, the time the individual was notified, and shall be carefully noted by the inspector. Alright, where were we? The regional administrator will contact the director of the Office of Safety and Assurance Compliance, the assistant chief of the Council of Safety, and advise these of the circumstance that headquarters occur that they need them to the base of the formal enforcement. The inspector will submit a form, FRA Form 6188, with a check in the item yes, the narrative memorandum detailing the facts of a regional administrator, which should show as a subject violation report concerning the filing and the individual names, the recommendation for filling with the formal warning letter of the penalty memorandum must fully address each element necessary to make a case against the individual format described in Chapter 5. Regional administrator will co-sign the form FRA Form 618080 and mail the original to the individual being registered. The regional administrator will insert the regional subsequential calendar year number in the space provided with the upper right corner on the copies. The appropriate copy of the FRA Form 618080 original along with one copy of the memorandum and any attachments shall be forwarded to the Assistant Chief of the Council of Safety Office, Chief of the Council for further action. Do not use the violation report transmittable FRA Form 618072 for transmission, including those documented with the envelope with untreated, unrelated violation reports against the railroad or authors. The appropriate copy of the FRA Form 618080 with a copy of the memorandum should be forwarded to the RRS1 individual envelope with a Form 618080 marked on the outside with the appropriate copy of it shall be retained with the secure the regional file. The employer copy of the mail with the individual's employer. See Chapter 2 of the manual guidance for the preparation violation reports against the individual. Alright, 812.3. Chief Counsel warning letters, civil penalty, disqualification. Mail of 5 hard copies of individual liability form 618080. The individual liability memorandum, relevant and appropriate supporting documentation to the IL expert attorney if unknown, but contact the Hazmat material staff director. 812.4. Privacy Act restriction. The Privacy Act of 1974, Title 5, U.S. Standard Code 552A, was created in response to concern about how the creation and using personal data might impact the individual's privacy act rights. If safeguard privacy is about the creation of 4 procedural substantive rights in personal data. First, it requires government agencies to show individual any records that kept on him or her. Second, requires an agency to follow certain principles and fair information practices rather than gathering and handling of personal data. The third places restrictions on how agencies can share individuals' data with other people's and agencies. Fourth, it allows individuals to sue the government for violating provisions. Therefore, the FRA employs that can be held with a personal liability unauthorized release for the information from any system of records about individuals maintained by the federal government. A system of records is defined by the entity of the group of the records where information is retrieved by the name of the individual by individual identified a database and collection of the records. Do not allow the retrieval of the information on particular individuals are not included. The FRA has 2 system records, one kept on the Office of Railroad Safety and the other kept on the Office of Chief of the Council. Concerning the compliance of the railroad safety laws, the individual included in those systems of records and one information contained by the FRA Form 618080 notice concerning the individual to whom the notice was addressed. 2. The any other information contained in the system of records concerning the individual noncompliance, such as a computer or paper file on a particular violation by individual which the individual is being investigated, warned, or cited for the penalty as an individual. In order to prevent the existing of the secret database agencies must publish the details of all their systems of the record of the Federal Register. The publication must cover the intended use of the system, allow our uninterested person to submit written data views and their arguments to the agency. Agencies are permitted to make certain disclosure of the Privacy Act system of the records where necessary for their certain regular use of the notice proposing such regular use has been published in the Federal Registry. Commented period had run. The FRA has established following regular use of the information contained with the Office of Railroad Safety individual. Enforcement case system. To review the record to determine whether the case should be forwarded to the Office of Chief of the Council for prosecution. 2. Otherwise review the records for the accomplice for the mission office of the Railroad Safety. To disclose the pertinent information with the records to any source of the which individual information is requested for the course of conducting the investigation for the extent necessary to identify the purposes of the request and to identify the information requested. To provide notice for the investigation and the outcome of the individuals employing railroad offers and other railroad related to the case of the joint facilities tracking the rights in order to give those entities the information they need to assist in preventing a recurrence of noncompliance, to provide information that concerns enforcement actions of violation, safety statute, regulation, government action, regulated industries, in order to provide them with the information necessary to carry out their responsibility, to provide with the information concerning enforcement actions, violation, safety statute, regulation, public in order to increase the deterrent effective efforts of the sections, kept in public informed about how the laws are being enforced. All right, Title 55 Federal Registry 17851, April 27, 1990. These regular use are provided with the regional permissions. The field inspector sufficient flexibility to accomplish the permission without running out of afoul of the Privacy Act. For example, the third use of the clear permits inspector to discuss those information about the individual to any source of the pertinent information with the consent necessary to identify the purpose of the information requested. The identified information requested, or only on the fact that the investigation is beginning, conducted with the name of the individual shall be provided with the person with whom are you requesting information. The fourth, regular use of the permits of the regional office to send a copy of the FRA Form 618080, notice of the individual's employing railroad or officer. However, in order to ensure the regular use of the not misapplied, but the applied inconsistently disclosure information of individuals to those other outside of the FRA, other than those types of disclosures discussed in the preceding paragraph, may not be made without prior approval of the Office of Railroad Safety, which consults with the Office of Chief of the Councils on a priority of any of such disclosure. Moreover, the certain rules on storage records on individuals must be observed in order to comply with the Privacy Act. Accordingly, the inspectors are not maintain the file copy of the records in non-compliance with the individual after the forward of the notice concerning the individual in the region. Instead of the inspector submitting their file, the regional administrator will establish a secure file for all such records, which ensure, except as discussed, no information contained in this file released without authorization of the railroad safety information submitted by the individual will be placed in the file along with other pertinent records. The files will be stored in the file cabinets that will be locked after working hours. Automated files will be password protected, will only be retrievable by direct terminal access with the selection of data elements determined by the authorized user. Manual paper records will retain for the period of 3 years. Automated computer records will be maintained for 5 years. Consult with the Office of Chief of Counsel prior to disposing of any records that may be still subject to any enforcement action. Disposal will be shredded, except for the certain automated records will be retained, identified, and to provide complete compliance histories. To avoid problems in areas, the regional field personnel should be following the general rule, except for the sending of the individual's employer to the copy of the FRA Form 618080 notice. Do not disclose the records about individuals to discuss information in those records without any outside of the agency, except as necessary to complete with the investigation. Any resulting enforcement action is specifically authorized of Office Railroad Safety. If you are doubted how to handle the situation of question pertaining to the Privacy Act, contacting the Office Chief Counsel through the regional management. This page is intentionally left blank. This is chapter 9. It's here, and then we have another 8-page reading.